we recently had an ICC arbitration that where the principal claims surrounded force majeure, so this is something that is at the top of our mind. And we're getting a lot of questions about force majeure from clients because of the difficulties in performance in light of the recent coronavirus outbreak and the disruption to global supply chains. So what is force majeure? Well, first, force majeure is a contractual provision. I think that that's something that's significant and important to identify off the bat. Typically whether or not you're going to be able to claim force majeure is going to be dependent upon the individual factual circumstances of your contract, but also what your contractual language says itself. So what force majeure typically does is where a party is unable, due to a force majeure event, from performing their contract, and it's usually an unforeseeable event that is not the fault of the party claiming force majeure, and they can't perform because of that event, and it falls within the contractual provision, then they may have a valid force majeure claim. Now, what is a qualifying event? Well, the contract usually at least lists some of these events, but they don't include exhaustive lists. For example, you see things like force majeure due to war, embargo, acts of terrorism, labor shortages, riots, but also natural events. So you do see some force majeure clauses that talk about, floods, earthquakes, tsunamis, things of that nature. And some of them also do talk about epidemics. The World Bank has a draft, sort of model force majeure clause that they make available, which talks about plague, disease, epidemic as an event that will prevent performance. But in the common law system, where we practice mostly, force majeure is strictly a contractual claim. If you are looking at force majeure in a civil law jurisdiction, there are sometimes some statutory force majeure events, and that's going to really go jurisdiction by jurisdiction, country by country. And so, really, if you're thinking to yourself, either my counterparty is saying they can't perform because of the coronavirus, or you're saying that we can't perform our contractual duties because of the coronavirus, I think there's a couple of questions that you want to ask at the outset to know whether or not that this is in fact force majeure. I think the first one is, is there a contractual force majeure provision? I mean, start at the beginning. If there's not, and you're not in a civil law jurisdiction that has a code provision, then you can't claim force majeure in all likelihood. The next is, what performance under the contract does the provision apply to? As I alluded to, you have to prevent performance. It's not enough if performance just becomes more expensive or burdensome, or even the market for your products is not as robust as it once was. That's really economic harm, which is not what the touchstone is for force majeure. Then we have, what is the event that occurred? And is it an event that falls within the contract? Was the event beyond the reasonable control of the party claiming force majeure, or without the fault of the claiming party? In the instance of the coronavirus, probably there's no assignment of fault, but that's not always the case. Was the event unanticipated or reasonably unforeseeable? Different states have kind of different requirements about whether or not foreseeability matters. But as I said, it's got to prevent your performance. And along those lines, you have a duty, if you're claiming force majeure, to make commercially reasonable efforts to remove the event of force majeure. And we're going to talk about that with Andrew, about what that might mean and what that might look like. But ultimately, as we might find ourselves on both sides of this issue, and this isn't an issue as a law firm, this isn't an issue where you need to be ideologically pure, because in fact it is so fact specific and it is so contract specific typically. So I don't think we're in a situation where we're saying things that are going to apply in every circumstance. You're really going to need to get into a bit more of a granular inquiry. But Andrew, having just gone through this and having just done a major force majeure case that lasted several years, the one thing that I think came up in our case, and we're not going to get into specifics, but is this concept that you have to draw a straight line between the event of force majeure and why you can't perform. And that raises a couple of questions for me that I wanted to ask you, which is, first of all, how do I determine whether or not this is even a qualifying event of force majeure? What sorts of things should I be looking at to determine that?
Well, I think you alluded to it in what you've said. The touchstone for a force majeure claim is the contract. And so the first thing you have to look at is to see in what situations you have the right to make a claim under that provision of the contract. Usually, force majeure provisions relate specifically to your own obligations, so things that you are contractually obligated to do under the contract. So that's a distinction that matters when you start talking about you receiving benefits under the contract, because that is not something that a force majeure provision typically covers. That's not an absolute requirement. It can change depending on the language of the contract, and certainly, again, contract is always the first thing to go back to, but typically it's an obligation.
Yeah, so let's talk about, let's get into that a little bit, because I think that, an obligation to purchase something is a good example, right? So I might, have contracted to take a particular piece of equipment for a factory, but my factory is shut down, let's just say, due to quarantine. But in my specific contract, my obligation is only to pay for the equipment and to receive. So we actually dealt with this, quite recently, where it really was parsed as finely as, well, you can really physically pay, and you can really physically receive what it is that you were designed to pay for. Now, you no longer have a use for this piece of equipment, but it seemed to me that, maybe in that type of situation, you're failing that line that you're drawing between, actual performance and simply, a lack of commercial utility for the thing that you wanted in the first place.
Yeah, it's definitely a red flag. I mean, again, I would stress that because this is a contractual doctrine, you could have language in a contract that reads a little bit differently. But I think typically, if you're reading a contract and what the force majeure provision protects against is an inability to sort of meet your obligations, that's something a court or an arbitration panel is going to take seriously.